Rome Statute of the International Criminal Court, Functions and Powers of the Pretrial Chamber. Article 57. Functions and Powers of the Pretrial Chamber. 1. Unless otherwise provided in this statute, the pretrial chamber shall exercise its functions in accordance with the provisions of this article. 2. A. Orders or rulings of the pretrial chamber issued under Articles 15, 18, 19, 54, paragraph 2, 61, paragraph 7, and 72 must be concurred in by a majority of its judges. B. In all other cases, a single judge of the pretrial chamber may exercise the functions provided for in this statute, unless otherwise provided for in the Rules of Procedure and Evidence or by a majority of the pretrial chamber. 3. In addition to its other functions under this statute, the pretrial chamber may a. At the request of the prosecutor, issue such orders and warrants as may be required for the purposes of an investigation. B. Upon the request of a person who has been arrested or has appeared pursuant to a summons under Article 58, issue such orders, including measures such as those described in Article 56. Or seek such cooperation pursuant to Part 9 as may be necessary to assist the person in the preparation of his or her defense. C. Where necessary, provide for the protection and privacy of victims and witnesses, the preservation of evidence, the protection of persons who have been arrested or appeared in response to a summons, and the protection of national security information. D. Authorize the prosecutor to take specific investigative steps within the territory of a state party without having secured the cooperation of that state under Part 9 if, whenever possible, having regard to the views of the state concerned. The pretrial chamber has determined in that case that the state is clearly unable to execute a request for cooperation due to the unavailability of any authority or any component of its judicial system competent to execute the request for cooperation under Part 9, e. Where a warrant of arrest or a summons has been issued under Article 58, and having due regard to the strength of the evidence and the rights of the parties concerned, as provided for in this statute and the Rules of Procedure and Evidence, seek the cooperation of states pursuant to Article 93. Paragraph 1, k. To take protective measures for the purpose of forfeiture, in particular for the ultimate benefit of victims. Article 58. Issuance by the pretrial chamber of a warrant of arrest or a summons to appear. 1. At any time after the initiation of an investigation, the pretrial chamber shall, on the application of the prosecutor, issue a warrant of arrest of a person if, having examined the application and the evidence or other information submitted by the prosecutor, it is satisfied that a. There are reasonable grounds to believe that the person has committed a crime within the jurisdiction of the court, and b. The arrest of the person appears necessary. I. To ensure the person's appearance at trial. 2. To ensure that the person does not obstruct or endanger the investigation or the court proceedings, or 3. Where applicable, to prevent the person from continuing with the commission of that crime or a related crime which is within the jurisdiction of the court and which arises out of the same circumstances. 2. The application of the prosecutor shall contain a. The name of the person and any other relevant identifying information. B. A specific reference to the crimes within the jurisdiction of the court which the person is alleged to have committed. C. A concise statement of the facts which are alleged to constitute those crimes. D. A summary of the evidence and any other information which establish reasonable grounds to believe that the person committed those crimes, and e. The reason why the prosecutor believes that the arrest of the person is necessary. 3. The warrant of arrest shall contain a. The name of the person and any other relevant identifying information. B. A specific reference to the crimes within the jurisdiction of the court for which the person's arrest is sought, and c. A concise statement of the facts which are alleged to constitute those crimes. 4. The warrant of arrest shall remain in effect until otherwise ordered by the court. 5. On the basis of the warrant of arrest, the court may request the provisional arrest or the arrest and surrender of the person under Part 9. 6. The prosecutor may request the pretrial chamber to amend the warrant of arrest by modifying or adding to the crime specified therein. The pretrial chamber shall so amend the warrant if it is satisfied that there are reasonable grounds to believe that the person committed the modified or additional crimes. 7. As an alternative to seeking a warrant of arrest, the prosecutor may submit an application requesting that the pretrial chamber issue a summons for the person to appear. If the pretrial chamber is satisfied that there are reasonable grounds to believe that the person committed the crime alleged and that a summons is sufficient to ensure the person's appearance, it shall issue the summons, with or without conditions restricting liberty, other than detention, if provided for by national law, for the person to appear. The summons shall contain a. The name of the person and any other relevant identifying information, b. The specified date on which the person is to appear, c. A specific reference to the crimes within the jurisdiction of the court which the person is alleged to have committed, and d. A concise statement of the facts which are alleged to constitute the crime. The summons shall be served on the person.